any wrongdoing in demand guarantee scandal that led to its suspension in power distribution deal with ECG. We've secured exclusive documents detailing the findings of MEDA, the Millennium Development Authority's investigation into the matter. That is still awaiting the government's own conclusion. But remember, that is what the U.S. government says they're going to be working with. Tonight, we know from those exclusive documents that PDS did no wrong. Exclusive details coming up here on Top Story.
This is Top Story with Evans Mensah.
And Top Story is always brought to you by Bond Savings and Loans. Your success, our passion, also brought to you by Gasem Cement, the nation builder. Vodafone, the future is exciting, ready, as well as Nationwide Health Insurance, your healthcare family. In the last few minutes, Joy News has secured details of the Millennium Development Authority's investigation into the PDS scandal. And the conclusion is a simple one. The conclusion is that the investigation did not identify any information to suggest that either PDS, CalBank, Danwell, or personnel from the Millennium Development Authority committed or conspired to commit fraud or other malfeasance in relation to the demand guarantees. And a little background to this. A little over a month ago, news broke the government has suspended the PDS arrangement, the concession arrangement with PDS. Why? Because they had detected breaches in the demand guarantees that were issued. Subsequent to that, we heard the energy minister raise a scepter of fraud in that particular deal, which he says necessitated government decision to suspend the PDS concession arrangement. Subsequent to that, a committee was formed by government to probe the circumstances in which the alleged fraud occurred, which really bordered on one single signature, which we were told had been forged, and that belonged to one of the executives at Alcoot, which is the insurance company that provided the guarantee to cover the PDS deal. Now, that government team traveled to Kuwait and also traveled to the US to probe this matter further. But the Millennium Development Authority, which really guiding this whole process, also set up its own investigations backed by the U.S. government. Remember, the U.S. government issued a statement saying that they will work with the MIDA commissioned investigation into the matter. So there were two parallel investigations that were being carried out. The government investigation, which we understand is complete. The report is to go to the president for final word, and then the MIDA internal investigations, which the U.S. government would, and they were giving us the money for the improvement in the power sector, backed. That MIDA investigation is a copy. The report is out now, and we have secured exclusive copy of that. And that report clears the PDS of any wrongdoing. My colleague Raymond Aqua has a copy of that report as well, and it joins me as we go through what they found for you tonight. Raymond, let's go straight to the conclusions, because that sums up for us in quite great detail what the key issues were.
Very much so, and it talks about they reviewing background documents, interviews conducted, and independent investigative analysis performed to date, and they conclude first and foremost that the payment securities that were presented by CalBank and PDS to MEDA on February 27, 2019, which were subsequently accepted by the Ministry of Finance and ECG, are compliant with the recommendations contained in the URDG 758. First point. Now, the second point to make is that we have not seen any documents that would suggest that as of March 1, 2019, PDS, CalBank, Danwell, and all personnel from MEDA should have questioned the validity of the payment securities. They further note that the officials from Alcoot confirmed to KNL that the stamp applied on the acknowledgement and agreement page of the payment securities is that of Alcoot.
Okay.
And also say they further confirmed that the signatures are that of Al Nuri and Fadi Dobon, who are employees of Alcoot.
And that is substantively a very important point to note, because that was at the heart of the controversy.
There is, however, to it this way. It says, however, given that ECG is the beneficiary of the payment security, they sought guidance from the government of Ghana's financial advisors on what the best protocol will be to confirm the authenticity of the demand guarantees. We further understand that Hampton advised ECG to, Hampton is the advisors in this case, ECG to contact Alcoot directly using the contact details other than those contained in the demand guarantees to obtain confirmation directly from Alcoot that the demand guarantees were genuine and were validly issued.
So let me explain this. So at the point where the demand guarantees came it came through several channels. First, it started with CalBank. CalBank then brought in Downwall Insurance, and then Downwall Insurance then brought in a broker called Joe Australia, and that company then was supposed to do the deal finally with Alcoot. Now, the important point to note here is that when the demand guarantee was first issued and signed by Mr. Al Nuri, that particular document became a subject of some controversy. The ECG had to verify that. Now, the advice that has been hinted in this investigation was that instead, and the demand guarantee came with contacts on the face of the document.
Yes.
Okay. The advice was simple. Instead of use the contacts on the face of the document, go directly to Alcoot to verify if the signatures that are on the document are true, and the individuals who are signing the document have the authority to do so. And if you read elsewhere in the document, ECG denies that they were given that advice.
That's true.
ECG says that they were not given that advice, but they themselves took upon themselves to verify, go beyond the document, the details in there, and do the verification with Alcoot. It was that verification that led to the senior officer, Musa Haq, who was in charge of reinsurance, to say that, listen, the person who signed this, yes, worked with us, but they didn't have the authority, and so we don't have any deal with you.
Yeah, that point is also made in the subsequent one. It says that there were specific reviews that was done, and Alcoot's delegation of authority, which was produced by Alcoot to government of Ghana, Al Nuri does not have the authority to bind all Alcoot in relation to the demand guarantees without the board's approval, which they have seen. Of course, they have not seen as part of the executed PDS transaction documents. However, there's a note to that. It says, however, as noted in the KNL's legal analysis to FTI, in a cassation court judgment, the court ruled, and in this particular case, the reference is made to the law court case, in favor of a party who, in good faith, entered into a transaction which was executed by an authorized individual of the other party. In that case, the cassation court held that the doctrine of apparent authority applied where an employee fraudulently submitted a purchase order with company stamps in circumstances where she indicated that she was representing her employer. Therefore, the employer in that case was held liable for honoring the obligations entered into by their delinquent employee. And it says here, while this case may provide a basis to proceed in a lawsuit against Alcoot, it should be noted that KNL stated that it is difficult for KNL to determine whether or not Al Nuri had apparent due authority to bind Alcoot. They would need to do a separate and further analysis to make that particular determination.
Okay, and so this is interesting. So they conclude that PDS did no wrong, but the problem still exists.
Yeah.
That the demand guarantees that were signed were not authorized.
Yeah.
You cannot execute. You cannot
by legitimate authority within
you cannot
Alcoot.
make a claim on it. Yes, the individuals in there. And so the big question that this raises is, as of today, it appears PDS, per the technical, haven't met that huge important prerequisite to qualify to still be the concessionaire, because the individual who signed it, and as the investigation had established, did not have the authority.
They provide more detail on the status of Al-Nuri in this particular case. It says the Technical Documents Authority list, which includes Al-Nuri as an authorized signatory to technical documents, provides corroboration that Al-Nuri had the authority. But unfortunately, this document fails to define or detail what is meant by technical documents.
Yeah.
Therefore, it does not provide definitive proof of Al-Nuri's authority to execute the guarantees.
And if you read elsewhere in the document, it also says that for such reinsurance products with such huge layout, and this was a $350 million insurance package that they were seeking, it needs the board's approval.
Yeah.
It required the board's approval, and it appears that was not secured.
Did not happen. Okay, now, and that, if you remember the particular July 16 letter from Musa Haq Osman, he detailed that too. That even if we're supposed to do something like that, the authority required to approve it was way beyond that of the gentleman Al-Nuri in this particular
Now,
case.
and let's move on to some other parts of it that are also interesting.
Yeah, the structure. You see, they make the point here. The structural changes made to the original form of the payment securities as contemplating the LLA and the BSA were approved by the MIDA board. An action that was in line with the prior instructions given by His Excellency, the Vice President, to authorize PDS to issue guarantees.
Now, I'm going to explain to you what the Vice President's role was. And his role was simply, and this is all part of the investigative document that we have for you tonight. His role was simply related to the changes that were made to the guarantees that PDS required, and different from what Parliament approved, because Parliament approved one document as a contract, but then when they went to execute, they realized that PDS could not meet those strict requirements that Parliament approved. So then there became the need to make changes. Right. That is where the Vice President came in to approve it. We'll detail for you exactly what his role was, and whether or not the Attorney General's opinion was sought as to whether or not the changes to the original parliamentary approval had to go back to Parliament for ratification. Because if Parliament had approved the document and you change it, ECG itself had concerns. Do we have to go back? And we'll tell you what the Attorney General said, because the advice is also here.
Very much.
Let's move on with the conclusions.
Now, there's a point that needs to be made about how PDS could not secure the demand guarantees, and what were the main stumbling blocks. It says PDS could not secure the demand guarantees or letters of credit as per the requirement of the LLA and BSA from a bank because of three main challenges: PURC's delay in approving the rate setting guidelines and the initial rates that PDS was authorized to charge, the delay in agreeing on the list of PPAs, that's power purchasing agreements, made, and PDS not having a certain level of capital required for the issuance of cash-backed security.
Now, that last point is interesting. It says that PDS not having a certain level of capital requirement, and the investigation established that PDS did not have the money that it needed to get the issuance of a cashback payment. Some of the banks they went to were asking for that.
Brilliant.
Show me your bank account, see how much you have there to carry what we intend to do with you, cashback payments, and they didn't have it. PDS simply didn't have it. 350 million.
Yeah, that's it. But the detail, even the demand guarantees in this particular case, they require some 12.25 million. This is how the PDS funded that particular 12.25 million. Of the 12.25 million that was charged by Car Bank to PDS as fees for raising the payment securities, only $1 million, that's 8%, was funded by an equity contribution by a PDS shareholder.
Okay,
and we know that this gentleman is Philip Ayensu, the board chair.
Yes. Now, if you pay attention to something that you read earlier, which is PURC's delay in approving the rate setting guidelines, and this is important because, and this comes to the heart of the minorities' concerns back then, which is that PDS and not only minority, civil society have said so, that PDS didn't have what it took financially to carry this deal, and what also necessitated the changes in the approved parliamentary document, that after they approved it, getting the bank guarantees became a challenge. One, because PURC had delayed in approving the tariffs, the rate settling guidelines for the tariffs, and so if you don't have the tariff, that will show how much you're going to make. Bring in. No bank will give you the guarantees you required, so that delayed it. Secondly, the delay in agreeing on the list of PPAs made is also important. I mean, so those delays made it impossible for PDS to raise the guarantees from the A-rated banks that they had originally approved by Parliament.
That's true.
Is the reason why they then decided to, okay, if that's the case, let's change the terms. You can bring us an insurance guarantee and we can work with that.
Now, so I was making the point about how the guarantee was funded, and that the board chair actually was the one that brought the 1 million, 8% of it. 7 million was funded by a loan that was advanced by Car Bank to another PDS shareholder. And we know that this PDS shareholder is also one person who's related to one Santa Baron, who actually was the one who was used in getting the money. This loan was repaid from operating cash flows generated by PDS after the transaction and transfer date. Now, the other point they make is that the balance of 4.25 million, that's 35% of the amount involved, was also paid directly from operating cash flows generated by PDS after the transfer dates.
Yeah.
So, 2
That's
points.
important, right?
Yes,
Explain that.
no, it's important because the presumption here is that you had the money to invest in there, and you had the money to actually pay for the guarantees. It was only 1 million that was paid up front. The other amounts involved here were really refinanced from the amount of money PDS got when it got into operating PDS as we currently have it, as in ACG as we currently have it. So these cash flows really are from the operations of the ACG as we know it to be today. So that's where the difficulty really is. So the 12.25 was not something that the PDS had. It was only 8% that it could get immediately from its shareholder. The other was a loan, and the loan was repaid with money from the ECG that's been taken over by the PDS. That's how important that particular point is.
Okay.
Now, the other point they make in this is that now, based on their reviews, Alcoot's underwriting guidelines, page 22, among other things, Alcoot would avoid coverage of guarantees and product warranties and quality. They proceed to say that Alcoot's article of association are silent on whether or not Alcoot is permitted to reinsure a portion of risk assumed by a primary insurer and the demand guarantee governed by the uniform rules of the demand guarantees by other rules. In addition, KNL confirmed that pursuant to Article 13 of the Articles Association, Alcoot is permitted to work with other companies as long as the nature of the work is within Alcoot's objectives as listed in the Articles of Association.
Yeah.
Now, it proceeds to say that it appears that personnel from Alcoot's reinsurance department previously engaged in transactions that are similar to the PDS guarantees.
Okay.
Now, and proceeds to say that these transactions, which leveraged the strength of Alcoot's credit rating, were brokered by Joe Australia Insurance.
Same
institution that brokered the deal with Danwell for and on behalf of PDS and Car Bank with Alcoot in this particular case. Now, and reinsured by Alcoot, and which with further instructions by Alcoot to Joe Australia to retrocede them to other reinsurers. Based on an arrangement with Joe Australia, a 10% fee confirmed that 15%, a 10% fee was credited back to Alcoot in these transactions. And in the case of the PDS guarantees, FTI confirmed that 15% was retroceded back to a local Ghanaian insurance company. And this we know is the Danwell Insurance in this case. Thus, it appears that Alcoot acted in a manner that would be expected of if the demand guarantees that were issued were valid.
So this is a very important point, actually, that the investigation is uncovering.
Yeah.
That everything else Alcoot had acted
Yes.
or had done since Al-Nuri, the individual they claimed it was not authorized to sign it.
That's true.
Everything else they did post the signature or the execution was consistent.
Including giving part of the money to the Ghanaian insurance company
Exactly.
that contracted them.
Was consistent with what they would have done if that document that was signed was valid. I mean, and yet they claim it isn't valid because the individual, they don't have the authority. It raises questions.
That's true.
And we must know this investigation, they state at the beginning that they are simply doing an investigation. MEDA will have to make a decision whether they want to sue.
Yeah.
Whether they want to sue Alcoot.
And the basis for which they can sue
Alcoot,
and how
yeah.
the limitations will be in the suit in this case.
They are providing this information.
Yes.
Government, MEDA can decide based on this information with their lawyers that we're going to sue Alcoot. But that's a decision for later.
Yeah. Now, they made the point and they conclude, and that's the conclusion you started the show with. We have not identified any information to suggest that either PDS, Car Bank, Danwell, or our personnel from MEDA committed or conspired to commit fraud or other malfeasance in relation to the demand guarantees. So that's how they conclude the 11-point conclusions in this particular report.
Now, I want to quickly refer to the one of the controversial points that has to do with how the agreement that was approved by Parliament was varied, okay, and what the role of senior members of government were in the variations that were made, and whether or not the Attorney General's opinion was sought after the variations were made, what the Attorney General's opinion was in this particular matter, and what happened since that, and it just relates to if you go back to the points surrounding that particular one. I want to read from the portions of this document that has that. It says, with respect to the payment securities, the financial advisor's representation noted the following: a letter of credit, and this is a quote, a letter of credit or demand guarantee from a commercial bank that meets the ratings requirement results in a simple structure. So this is what was an original approval, right? A letter of credit or demand guarantee from a commercial bank that meets the ratings requirement results in a simple structure, right? 2, a project finance letter of credit or demand guarantee from a commercial bank. And 1, provides security to ECG, also provides comfort to Ghana, and this would have happened if we have secured these things. Also provides comfort to Ghana that the issuing bank has conducted a proper credit analysis, that the transaction is bankable. A project financing should take 6 months or more to implement. So PDS has proposed that insurance companies issue the payment security. That's what they proposed. That they want the insurance company to do instead of the bank. Now, we are not confident, and this is an important note by an investigation. We are not confident that the insurance companies have analyzed PDS credit and understand the risk they are assuming. That's what the investigation found. Now, a demand guarantee from an unrated insurer introduces additional complexity, resulting in significant effort on due diligence and structuring. Now, as a way of mitigating the risk of PDS proposed insurance-backed demand guarantee structure, right? They knew that if they had gone for the insurance guarantee, it introduces risk. So they wanted to restructure it. Okay. The financial advisors recommended that MIDA board continue to work with PDS and the insurers to confirm the payment security structure. The specifically recommended steps included refined documentation to, among other things, ensure that ECG will have a direct claim against insurance, so they can go directly, right? Confirm the level of risk primary insurers will cede to insurers. Consider suitability of ratings requirements for insurers. Primary insurers are not rated. Confirm identity and ability of insurers to pay, which are all things that they must do for due diligence. Also, confirm identity and ability of primary insurers to pay. Now, listen to this, Raymond. We understand that at the formal board meeting, and when they made the changes, at the formal board meeting, the represented MIDA board members accepted the structure in principle and charged the stakeholders to work with PDS and CalBank to agree on the text of the demand guarantees. Now, it is, however, important to know that although the represented MIDA board members accepted the proposed demand guarantee structure, the final approval was given during a meeting with the Vice President on February 19,
Tuesday, February 19,
2019, right? And the Ministry of Finance and ECG were the parties who were involved in the acceptance of the final payment securities. Now, based on the documentation reviewed, and this is documentation that the MIDA investigation reviewed, right? Based on that, an email was also sent on February 19, 2019 by MIDA to confirm that as per the instructions of His Excellency, the Vice President, they wish to inform the recipients of the email that MIDA was willing to give PDS a notice to proceed to issue the demand guarantees for the BSA payment security and the lease and the lease payment security. Among those copied on the email were the Minister of Finance, Chairman of the ECG. And Raymond, note this. Then an email from MIDA to the Minister of Finance on February 27th, copying amongst others the Minister of Finance and other Chairman of ECG, states that the following the details what they had agreed to do. Thereafter, the guarantees were drafted after they had approved, were drafted by MIDA advisors and agreed to by CalBank and PDS. The meeting at the Jubilee House was chaired by the Vice President Others at the meeting included the Chief of Staff, Honorable Minister of Finance, 2 Deputy Ministers for Energy,
yes,
Media Board Chair, ECG Board, other senior officers from these ministries and agencies were all present at the meeting. At the end of the discussion, Media was instructed
to authorize PDS to issue the guarantees.
Okay. And note that this was when PDS got into difficulty, that they couldn't get the guarantee from the bank.
Yes, from the area.
Okay, so they agreed to change all the terms and the structure, etc. The investigation says the approval was given at the highest level of government, okay, by the vice president. Now, the last important point we need to note is about the Attorney General.
Okay.
Because there was a point where questions were being raised, and what you needed an advice on what should happen. Now, they wrote, Media then writes, on February 27th, a scanned copy of the demand guarantees were sent to Media via email to the Ministry of Finance, copying the chairman of ECG, stating, among other things, that PDS has now submitted the executed guarantees. It has now been executed, right? Kindly find attached scanned copies of the guarantee. And let me know something about this. ECG complains that they never got an original copy of the guarantees. All they were given were scanned copies, and they requested for it, right? The email continued. We will be grateful if you would receive your authorization to accept the guarantees. The approved text of the guarantee are also attached. On February 28th, right, 2019, via a letter to the Honorable Minister of Finance and Honorable Minister of Justice and Attorney General, ECG confirmed the acceptance of the demand guarantees. Now, it should, however, be noted that on the same day, ECG wrote several letters, one of which was to ask the Attorney General what to do. And I want to quote it. It says, a letter to the Honorable Minister of Justice General seeking an urgent confirmation or whether there's a need for cabinet approval and parliamentary approval. Yeah. The Attorney General writes back and say, you don't need parliamentary approval. You don't need cabinet approval for the changes that had happened.
Ought to be made in this particular case.
Original
and you know that the minority complained about some substantial changes that they thought ought not to have been approved without they approving it, because they saw the previous documents. And this was to do with conditions precedent and whether they were converted to subsequent, and the major changes of who decides what guarantees are requested in this particular case.
So there was Attorney General advice. There was. Yeah. And Attorney General said, minority, of course, this is something that minority and civil society had complained about, that if you change the terms of the approval granted by Parliament, you need to go back. But I've heard on Newsfile, lawyers also argue that written into the contract that Parliament approved was a leeway for changes to be made without recourse to Parliament. Some lawyers have argued that as well. And the Attorney General seemed to agree with that, because that's the advice she gave, that the Finance Minister can execute and make the changes, and the Vice President indeed approved the changes to be made. If you're just joining us tonight, the investigations that had been conducted into the PDS scandal has cleared the PDS of any wrongdoing. And this is the Media investigation, not the government one. No, remember, Media did its own investigations. They have cleared PDS of any wrongdoing. We are still awaiting the government investigation, though, but I just have to note that the Media investigation is what the US government said they'll work with, and George Afe was the one who pursued that quite closely with Media. Have you spoken to your Media sources here, George?
It's still work in progress. Yeah, try to connect the dots.
But they were very confident that their investigations will sort everything out, and it appears that from what I'm reading from their own investigations, which was only given to them on the 3rd of September, nothing wrong happened. But the big question that remains from the document is, what happens now to the demand guarantees? Because Al-Quds still stands by its claim that the guarantee that their employees signed, he wasn't authorized and cannot be valid.
Yeah, still a lot of questions are being raised, Evans, based on what we're also picking up. It means that a lot of questions need to be answered, whether maybe the US government also behind the scenes, they're also doing their own investigations, and they would also want to see what that forensic audit would also suggest, whether indeed everything